Mr. Dang is even better with that, though. Matter of Dang is about crimes of domestic violence. The INA
Okay, so they're
Section 2.
dingus and dang.
Dingus and Dang, yeah.
Okay.
Different the UK and Vietnam, though. Very, very different non-citizens. But so Mr. Dingus, I'm sorry, Mr. Dang. Now you got me confused. It's about INA Section 237A2EI removability, the crime of domestic violence.
Mhm.
And it's not talked about very much. But before I get to what they held, Mr. Dang was found removable under this provision, but it doesn't bar him. He was a green card holder. It doesn't bar him from getting LPR cancellation. The only thing that is a per se bar, and don't say the only thing, but per the statute, is an aggravated felony. And it wasn't an aggravated felony. So the immigration judge granted him LPR adjustment. So he got to keep his green card. And he still appealed, even though DHS didn't appeal.
Uh,
And even though by appealing, the BIA could have possibly said, you know what, the IJ was wrong to even give you LPR cancellation. Mr. Dang risked it all and spent all that money, and he won. Mr. Dang, his Louisiana crime is not a crime of domestic violence, and it's an important case because the BIA clarified something that has been a bit murkier than it should have been, and that is, in order for a conviction to be a crime of domestic violence, it has to be a crime of violence, as defined at 18 U.S.C. Section 16A. It has to meet that aggravated felony definition. Now, it doesn't have the term of imprisonment, just to be completely clear, and we don't provide legal advice on these podcasts, but it has to meet that same substantive definition as the aggravated felony crime of violence. And so that means all of this case law from the Supreme Court over the last decade about what is a crime of violence, what is not, it all gets incorporated into the crime of domestic violence. And really, matter of Dang is about whether or not this Supreme Court case, US v. Castleman, which involved domestic violence in a different context, whether that gave a different standard for removability crimes of domestic violence, because Castleman did involve domestic violence, just not in an immigration context. And the BIA said no. Now, Castleman is not about immigration. The immigration domestic violence statute expressly references Section 18 U.S.C. 16A. So we don't care about Castleman. We only care about Stokeling, Johnson, and these other violent felony Supreme Court decisions. And so I'm not going to get into all of the specifics there. I get into it on the podcast, but it is a good decision for non-citizens, and it really clarifies that a crime of domestic violence is governed by the aggravated felony crime of violence definition. And, honestly, there was a time where that wasn't the best ruling, but with the DiMaia v. Sessions decision, or the Sessions v. DiMaia decision from a couple of years ago, where the Supreme Court found unconstitutional 18 U.S.C. Section 16B, that leaves only 16A for all of this. And 16A is much narrower than 16B. So with all of these things that have been stacking up over time, for the board to correctly issue a decision like matter of Dang is potentially far-reaching for non-citizens. It's complicated. I hope that was clear enough in 5 seconds.
For California practitioners, I had to learn this because the case had a marriage adjustment case pending for interview. The couple get in a fight, and the woman attacks her husband with a weapon. And then I was like, well, and they arrested her for a misdemeanor. And there was some BIA case in California that says if it's even misdemeanor domestic violence, but there's weapon involved, it automatically becomes removable offense. I'm not sure if it was conviction or even if it's just an arrest. They can tell there's something like that. Does that have anything to do with this stuff, or just throwing it out there?
Well, yeah, there's a lot. I don't know about all of that. I'm sure that there might be a bit more narrow there. With anything with immigration, it's statute specific. Yes, a misdemeanor can be an aggravated felony if it has at least a term of imprisonment of at least a year. So in California, for example, it couldn't be anymore because now California has the rule where you can't get sentenced to at least a year for a misdemeanor. Yeah. But a misdemeanor, you don't have that 1 year for crimes of domestic violence. So everything you just said, a misdemeanor crime with a domestic violence component, yeah, that could be a crime of domestic violence removability provision. But what matter of Dang is saying is that the statute would have to require a sufficient use of force. And it's not necessarily what the individual actually did. It's what the least amount of force necessary was. In matter of Dang, for example, there was case law for this statute where someone could be convicted of it just by doing offensive touching, not violent force, just touching them. Quite frankly, I didn't get into it on the podcast, but doing something sexual to themselves while touching another person, which is very offensive, but it's not violent. And it's not physical force. And so that's one of the reasons that this specific Louisiana statute is not a crime of domestic violence and is not a crime of violence. And so it's very statute specific. That's what matter of Dang is making clear. And the legal standard is 16A. That's what's important.